Hello, our dear viewers. Welcome back to yet another edition of the Women's Show here on Civic Space TV. Today, we are having a conversation about the succession bill. And to have this conversation, I'm joined with my lovely panel. I will let them introduce themselves. Yes.
Um, Hello, everyone. My name is Naima Isa. I work with FIDA Uganda, and I'm so honored and glad to be here.
Hello, I'm Joyce Nalunga Birimumaaso. I'm so glad to be here. I'm a member of the Leadership Code Tribunal. I've been an advocate for the last 21 years. It's a pleasure being here.
Good afternoon. My name is Susan Achen, and I work with Uganda Women's Network. It's a pleasure to be back.
Yes, it's a pleasure having all of you here. So, the succession bill. So last week, the succession bill together with the sexual offences bill was brought before the president to assent. However, he rejected both bills. And he rejected the succession bill on about 2 clauses. So just to give us a background of this bill, so the landmark constitutional case, law advocacy for women versus the Attorney General, ruled most parts of the Succession Act, that is the 1906 Act that is currently in force, unconstitutional. And it created quite a lacuna because courts of law were unsure how to proceed if, for example, they were not sure on how to distribute property when a deceased had died intestate. So a lot of things came in about the rights of women and how the act was discriminatory towards women, the rights of children. So today we just want to get into that and discuss what are the loopholes that were in the act, and how does the new bill address those loopholes? What are the opportunities for women and for children? Is it more fair? Is it worse? So that's the conversation we'll be having today. So I think I'll start with Isa. Why should we care about the Succession Act? Why should, culturally we should, they say that you can't prepare your will because then you are predicting your death. So why should we as a country care about the succession bill?
Okay, thank you very much for the question. I'm going to speak from a feminist point of view because I'm a feminist, for those that don't know. If you look at the Succession Act that we have, that's CAP 261, it's a 1906 law, which if you compare it to the situation now and the status of women now, it is quite outdated. And yes, the landmark case really highlighted it out. A good example was in a provision of that law, that when a widow ceases to occupy the principal, it provided that a widow ceases to occupy the principal residential property when she remarries, but did not say the same for what happens to the widower. So yes, the case really brought out the inequality principles that were in the case that we really did not, maybe someone might not really look at. And culturally, we know once a man dies, a woman is left vulnerable at the mercy of the clan members and the family of the deceased. So yes, it is important to discuss succession bills and amendments currently, because as women and women advocates, we're advocating for the rights of women and equality, and ensuring that the constitutional provisions that speak to equality during marriage, during the subsistence, also applies towards when someone dies or passes on. And I think that's why it is really, really important. And if you look at the bill, it's trying to make cognizance of the fact that we need to abide by the provisions of the Constitution in relation to the rights of the family. That's under Article 31. Affirmative action in favor of marginalized groups. If we look at the situation now, we have groups that are marginalized that need to be considered in relation to succession, which is not catered for in the act that is currently subsisting. Also, the fact, like I said, the rights of women also need to be taken into consideration. So with those, I think it is really critical as a country that we discuss succession. I know culturally, when you prepare a will, it's showing that you know, it scares the whole family. Is she thinking of death? Does she want to commit suicide? But you can never be too ready on what happens next. You cannot know. We might be laughing here, and the next time, you know, someone is hit by a car. So we need to be prepared. But there's situations where you're not prepared and you die intested. So as women and women organizations, how are we protecting or advocating for the rights of women being protected even when the spouse dies intested? Are they protected by the law? I think that's what is key here. Thank you.
Thank you. Joyce, I'll go to you next. So just for our viewers who may not be lawyers, they have no understanding of what was even in the old act, could you give us just a summary of what was the case talking about? You know, what was Lau talking about that is so terrible in the Succession Act that the bill seeks to address? What are some of the loopholes that it addresses?
Thank you very much. I'm personally very excited about the succession bill, and I pray that it is passed without prejudice to the clauses that are still very contentious. I would clearly say that the old act of 1906 was very gender insensitive. It was really premised of inequality, gender inequality. It had gender bias, you know, on the face of it. You know, when you look at some of the gender insensitive language, you know, it only mentioned about the heir and on the heiress. You know, it was talking about a widow ceasing to occupy the residential holding and neglecting to hint on the widower. So it had so many gaps and loopholes, and I'm excited that the bill has come out clearly to address some of these issues that are very pertinent to me personally as a woman. Most importantly, as a legitimate wife, I'm very excited about it because this law is trying to clarify between a side dish and a legitimate wife. You know, that at the end of the day, if there's demise of your spouse, you're recognized most importantly for your output as a legitimate partner, but also the fact that you have children out there that are supposed to benefit. So this new bill is a very good package for us women out there. It is an empowerment tool. It is a tool that is coming up to sort quite a number of issues that are very important to the women fraternity, but also it provides for our children. If you look at this new bill, you know, much as it hasn't yet been passed, it's talking about the clear distribution, you know, reserves that were not in the former act. The act was a little ambiguous. It was, in case of intestacy, it was allowing a reservation of 15% for the legal spouse, then 75 for the beneficiaries, 1% for the heir, and then also for the dependent relatives. But that new succession bill, the packages are very clear. 20% to cater for the maintenance, welfare, education. Of course, it is held in trust for the minor children. It's clarifying on who the minors are between 18 and 21. So it's very, very clear. It's coming out to clarify, to empower, and to also be a major tool that will allow the children's welfare to be catered for. Then it also talks about those aspects that were hard to talk about, the issue of the dependent relatives. Women for long have suffered with relatives, in-laws, you know, upon the demise of their spouses, the in-laws quickly come on to say we are going to grab the property. But when you look at the bill, it is very clear. Even upon the demise of your spouse, your percentage is clear. Even if you choose to remarry after 3 months, you'll still have a claim on the property. So I hope and pray that it is really passed because it's really addressing all the disparities and the lacunas. It may not solve all the problems, but we are somewhere in the women, as regards women justice and the women fraternity. Thank you very much.
Thank you. So Susan, I'll go to you, and let's just start where Joyce stopped about the distribution. So one of the issues that the president had was the clause that seems to suggest that in the absence of, let me say, children, and there's only the spouse and maybe the dependent relative, that the spouse will take 80% and the dependent relative takes like 20%. So his argument was that why would you give the spouse 80% and yet you leave the dependent relatives with 20%, and yet most of the time, those dependent relatives involves grandparents, uncles, nieces, and nephews. They seem to need the money more. Why don't we have, let me say, we maintain, because there's another clause that talks about 50% for the surviving spouse, and then 49% for the dependents, and then 1% for the customary heir. What do you think about dependents?
On that one, I would choose to disagree with our fountain of honor.
Yes.
Yes, dependent relatives, like Joyce has very rightly said, have been a known source of turmoil and strife, and property wrangles in families, especially where there are children involved, especially where there are minors involved. And it's also because the definition of dependent relatives is not well appreciated by society. Everybody assumes that they are a dependent relative simply because, one, they are living in the home of the deceased person, or two, occasionally, he was catering for, I don't know, school fees or regular upkeep. But then the definition is very clear. It's a person who substantially depends upon that deceased person, to the extent that when they are not there, life is completely bleak. They do not have a starting point. And those are normally children. Those are normally elderly grandparents. But if you go and question whether they do not have an option, you'll find they have an option. There's always someone else. There's a social network. There's a family network that can actually take care of some of these people. I have handled cases where paternal aunts who are married and are stable in their homes and marriages and have children who can actually look after them are claiming to be dependent relatives. Mainly because they are also privy to insider information about the estate. And it is that which they use to wiggle their way around. And for most of the part, you find that the actual beneficiaries, the actual dependent, is disadvantaged. Yes. And then again, it comes back to the contribution to the estate. You know, for the exception, with the exception of, say, customary land or family property to which this deceased person is entitled, most of the estate has been worked for, you know, by this deceased person. So again, the question comes: where is the fairness in sharing it almost equally? And yet this person has a surviving spouse. You know, so on that one, I would choose to disagree with the head of state, and still, of course, the percentages can be a discussion for another day. But I would still give more to the surviving spouse, because you can be very sure. No. Children do not entitle me.
That's true.
To
They don't
property.
entitle me to benefit from my husband. I benefit from him because by law, as his spouse, I am entitled. Yes, the children will benefit on in their own right.
Exactly.
Yes. Yeah. So the question of contribution, and I think for me that is why I actually appreciate this particular one. Yes, because it in recognizing the rights of women, especially in recognizing the rights of children and of girls, it is subconsciously, if I may use that word, recognizing the fact that there is a contribution
The woman makes.
a contribution that is made by the deceased spouse, which may not be material, which may not be financial, but in being married to that person, you have in one way or another contributed to the acquisition
building,
of to the building of that estate. And really, I think at that point they should be entitled to most of it. They should be entitled to most of it.
But I think it also helps that now they have kind of coincided with also the Land Act to make sure that there's an interest even in the property, which was not there before.
Which was not there before.
So, Isa, now we're talking about rights of women.
Yes.
And Joyce hinted to the side chick and the legitimate wife. But we, in these discussions that we have had, I think it also came out in the marriage and divorce bill that most couples are cohabiting.
Yeah.
And that a man will have about 5 side dishes with
apartments.
or cohabiting. I don't know if you can call them cohabiting spouses. Cohabitees. And each of them have a child. So this bill seeks to acknowledge the children, but not the cohabitees. And isn't that very problematic, given the fact that where these cohabitees mostly see themselves as wives, or even if we're to say that it's just one cohabitee, that you have been 20 years with this person in what we, for us, we do not, when you have kids, you
triplets.
Culturally, you're married 20 years,
70 years.
70 years, and they have never gone Simani, they are taking cows to you, know. So what, don't you find that problematic? Or
well, I think I will answer in 2 responses. First, I think it's problematic because then what happens to me who has been, cohabiting with a man like for 30 years, 40 years, which cases we've seen in most times. And if you look at the statistics of marriages in Uganda, vis-a-vis the population of people in marriageable age, you find that the majority of Ugandans are cohabiting and not, married. As long as they call you our wife, you think you're your wife. But now this doesn't take away the fact that legally, for you to have a right over something, according to the law, you should be married. And we have so many options of marriage. It doesn't have to be church marriage. Customary marriages are recognized in our country. Islamic marriages, where we know it is nikah at home, which is recognized. Hindu marriages. So we don't have a one way of what? Of marriage.
They will tell you, I can't pay the bride price, is too much. The family is asking for 10 cows.
You see, this goes back to women. The challenge we have as women is we think marriage is the wedding ceremony. And it being the wedding ceremony, you want something lavish. Oh, Joyce's wedding was worth 70 million. I want mine 120. That is not marriage. And I think this is one of the problems that we're facing as women, who should have been in a contracted a marriage and stay with your spouse legally. It's about the certificate. Me, I'll tell the women to wise up. A man shouldn't tell you we've been together for 30 years.
Everyone knows you.
But your mom, that's the thing we say.
Mama so and so.
Your mama so and so. Mama so and so does not make you a legal wife. And I think this bill is making it straight clear. It's going to now catch up with the men who have been, beating around the bush. Once the women are empowered to know, if I don't have the certificate, I'm not your wife, then maybe we will wake up as women and realize we need to do something about this. If you don't want to take me legally, then we shouldn't be together.
We shouldn't.
Yes, we shouldn't be together. Why should we be there for 3 years? It's okay. It's okay. You can restart your life again. And I think it's one of the challenges women face. You are even forced to stay in an abusive relationship when you're not legally married because you had children with this person. So I think this bill is kind of shaking the uncomfortable tables that we are comfortable with as women. It's high time we realize that we need to get that legal document and be proclaimed a wife. No, nothing hurts like when the person has died. You've invested all your energy, emotions, and money, and then the person dies and they tell you you don't have anything with this person. It's only your children. Do you know the emotional damage you get from that? So I think that bill is here to wake us up. We've been sleeping for those who have been cohabiting. I'm not saying it's wrong. Maybe you've been doing it not knowing it's wrong because the clan knows you. But it's high time people realize that even the clan knowing you, and I've witnessed this, once the man passes, even the legally married ones are tortured by the clan.
How about one?
How about you? That's how they will flip 360 and claim that they have never seen you. Issues to do with property and money, you just need to wise up. You need to wise up and be smart enough as a woman to protect your rights and those of your children. Now, if they say, he has no children, you have 80%. Fight for that 80% and get the legal document.
Absolutely.
That is the only advice I can tell women, as far as this bill is concerned. And we don't need to wait for the bill, by the way. We just, let's be proactive and hold these men accountable. You've been with me for years. We are cohabiting. The clan knows me, but Uganda does not know me as married to you. And that is by me getting the certificate. Yeah, I think that's the best thing women should do now.
Allow me to jump in from there. I believe that this bill should basically be used to sanitize the bad relationships, okay? Because like she has clearly stated that we cannot sanction an illegal relationship based on emotions. As we empower ourselves and the women and our daughters out there, we need to clearly formalize whatever relationships we have. We need to have a clear legal coverage over every form of relationships, because at the end of the day, our protection lies in the law, not in emotions. And the bill is also coming up to basically outlaw all those cultural norms and sentiments that were harboring, you know, the bad relationships that women have grown up into. Of course, I was hearing so many of my friends saying that I come from a side dish parent, I'm coming from a cohabitation. Yeah, you as a child, you're entitled to everything that you're supposed to have. That's why this bill has also outlawed the different categories of legitimate and illegitimate, you know, descriptions that were being given to the children. It's coming up to show that all the children are very equal. They're entitled to their beneficial interest. They have clear inheritance rights. But us, the adults in the relationships, are supposed to stand where we can benefit from legally. So let us embrace it in the positivity even before it comes out, and know that it's also recognizing the role of the women in decision making. You may be a housewife, but the fact that your husband was able to make apartments, was able to start up a kiosk or a supermarket or start a factory, then your decision making role has been highly recognized. Probably the ideas you shared at the dining table, the ideas you shared in the bedroom were the ones that anchored this gentleman to set up something. So our role as spouses is being recognized. The role of the widower and the widow is coming up very clearly. Before, it was only the widow that was being told that upon the demise of your spouse, you can leave the home. But now you're being recognized that you have a beneficial interest. At the same time, the property has to devolve among the beneficiaries. So it is a very good tool for us, and I believe it's going to enhance our affirmative action. It's going to enhance our safety and protection as women, as legitimate wives. And if you're still cohabiting and you're out there being soothed by your spouse, it's high time you really took the bill as something serious. It's an eye-opener for us women out there. We can't stay in the comfort of our homes when we don't know the legal protection that we have. So I thought I would emphasize that.
Okay.
Thank you.
Thank you so much. So Susan, I'll go to you. And basically, so I'm talking, this distribution thing is why the other act was also kicked out, you know. So 20%, and I'm looking at a person who has died intested, and for our viewers, that's a person who does not have a will. Tested is when you have a will. So I have 5 spouses, polygamous marriage, it's a Muslim marriage. This 20% for 5 wives of mine, really, is it fair? Is it supposed, or is it supposed, am I interpreting it wrong?
It is, you're not interpreting it wrong. I was privileged to sit in a number of discussions held by the policymakers, of members of parliament, in some of these very discussions. And one of the reasons that the issue of the distribution to spouses, to widows in particular, became an issue was that they have contributed something. So therefore, the percentage devolving to them should also increase. But on the other hand, the argument to still leave the bulk of the estate, benefit of the estate to the children, was because of the, you know, they were taking into cognizance the fact that many of these children might still need to go through school, might still need to, you know, they need that security.
So the
You
wives
know,
can't do
which if left to the wives, supposing they remarry, supposing
But women
they
can't
sell,
abandon their children.
I know,
They
right?
can't leave
But
their
I
children.
think it comes
They
also
cannot
to when
leave
the
the
children are
children.
not your own.
Probably the, you know,
So
That's
the
the
those
security
steps or
for them.
something.
were
then
the
I was thinking
arguments
we
around
distribute
it.
Okay.
Those were the arguments around it. And at one point, like you mentioned earlier, the percentage had actually been put at 50%.
That would have been better than
Yeah,
20.
I think
20 is
so.
way too little.
Yeah, 20 is
Yeah.
way too little, especially if there's more than one.
Yes.
Wife.
More than one
One spouse.
One spouse. It's not realistic. It's not meaningful.
Yeah.
Especially when you look at our estates.
Exactly.
Yes,
Definitely.
most of them are small.
They're not
meager,
quite big, yeah.
Yes, you know. So it's not meaningful, but
Something to start with.
it is something to start with. For me, what I particularly I appreciate that there's a 20% that has been left
For interest.
surviving
interest.
spouse.
For
Yes,
maintenance
thank you for
and
that.
welfare.
Yes, interest for the children. But I still wish that what was coming to spouses still
Probably 40%.
yes,
That
was
would really
bigger
be
than
good.
that,
Yeah.
because the question of
For
contribution is one which I think as a country we really need to start talking about. We really need to start talking about it, because that is what that estate is about. And you
That's
cannot
true.
live with this person for a number of years and you
Yeah.
are not making
Any
anything.
contribution.
Exactly.
Yes, and you're getting the short end of the stick
Yeah.
at the end of the day. It's not very
It's not fair. It's not really fair.
Yes, so the 20% slight increase, we go with it.
And why would the heir get 20%? I find it a little
No,
funny.
The heir, thankfully, I'm saying thankfully, with a lot of happiness,
Yes.
is getting 1%.
1%.
Because
That's
you
a
know,
joy for me.
this
Yes.
title of heir
Yeah.
is so, it's
People
so
have abused
glorious.
it.
Yeah.
They've
Yes.
evicted widows based on that ticket of a
Yes.
customary heir.
It gives you so much power. Then you come and evict everyone. You grab everything. You take over what is not yours.
Yeah.
You harass the widows
You
and
harass
yeah.
the widows and the children and any other
Actually, they're
beneficiary.
contemplating removing the whole thing altogether.
Yes,
right?
That would
So-
have been much better
But in the
because
name of culture.
Yes, maybe the dignity of culture and respecting
Yes.
our culture. 1% is okay.
Is okay.
But still,
the only trouble is that we do not know that it is 1% because of our cultural values, our cultural practices. Normally, the heir is the owner.
according
But
to
also,
culture.
some
that.
people have made the argument that it's like usually the heir is also the son.
It's not obvious because
necessary.
if you only had daughters as a legitimate wife,
Yeah.
can be the son of
for the daughter.
Yes.
Someone else.
yes,
But-
someone. The
But
girlfriend or
still,
something.
Yes,
I
but you
think,
see-
sorry to cut you short, but I was thinking, like you're saying, heirs abuse the rights.
That's true.
There's a case that I'm dealing with right now. And this heir, upon naming himself, I think he did that because the widow was not involved in the naming of the heir,
yeah,
went and changed almost everything
into their
his
names.
name,
Yeah,
Yes.
and had the audacity of taking the widow to court.
can you
Can
imagine?
imagine.
And I'm thinking, okay, so with the 1% that you're going to be entitled to, and you want to take a widow
To court. Who has
whose
much
property was bought because the husband said,
Exactly.
this is your car, I'm
Yeah.
getting this house for you, I'm getting this land for you. But because you're the heir, you have the audacity of reverting all that property that was gifted to the wife to your name because you're the cultural heir. So I hear you. I hear you,
yeah.
what you're saying. Yes.
I agree entirely.
Okay, thank you so much. I also want to go on another clause that, according to lawyers, that the president might have misunderstood, and that's why he rejected. So about separation. You know that in the old act, if you had been 6 months separated consistently, you had no interest in the property. Am I right? So the new act talks also about separation
Yeah.
and the fact that you have no interest. Am I right? And before it was talking about legally, separation must be legally or have been agreed upon by some agreement.
Yeah.
You get it. Might not be legally, but we agreed that let us separate. So one, he said that the whole idea of an agreement might be ambiguous.
Yes.
Like at what point did I agree with you and all those things. And you know how men can take advantage of that.
Yeah.
The second one is that legally separated might be unfair because and the lawyers might have agreed with him on the fact that when you're legally separated, the only thing that is suspended as a right is
Conjugal rights.
conjugal rights.
Yes.
You reserve all the other rights as a spouse,
Yeah.
and therefore, if he dies, it's not that you stopped being his wife
yeah.
or the husband. It's only that you stopped having conjugal rights.
Yes.
So would it be fair to disinherit someone because
Of
you're not
conjugal
sleeping with them
rights.
anymore?
No, I don't think it is right.
Don't you think the president had a point in that regard?
It's a little ambiguous.
Well, it's ambiguous
Yeah,
per
it was
se,
ambiguous.
but now my question, as you're speaking, my mind was, you know, what if the legal separation was because of, let's say in this case, the deceased who's the husband. But if it's due to the domestic violence that I decided to, you know, separate or agreed to stay away from you and deny your conjugal rights, then what? Should I be denied my inheritance rights when you are the problem for me separating? You're the cause for me separating from you.
Yes, I think the Act also addresses something like that. It talks about if you are the one being separated from, that it is not necessary that you're going to be disinherited. I don't remember that clause though. I think it was to protect women in that way for the men who just leave and
for men who just move away and who, you know, you're separated because of abuse. The previous law was, you know, really unfair because
true.
What if it's because, you know, domestic violence and all that I moved away, and I think this the bill is coming to remedy that fact. And it says even if you're separated and the person, you know, demises, then you have the right to inherit. Yes, there could be a misunderstanding, a misinterpretation, because it's ambiguous and it really needs maybe to be brought out, because, you know, with lawyers, the ambiguity and the argument, who makes the best argument in court is what? So there is wobbling and a little bit of wiggling there. So I think, that was right. He needed to bring it out for people to understand what that really meant.
I also find that that clause 30 very, very ambiguous. And I think it needs a lot of clarity by the lawmakers so that it's not abused by either party. Okay? Because I also feel like my land colleague has ably submitted that someone's separation for reasons beyond their control should not be used as a bar to their inheritance rights and their beneficial rights. Because, for example, if someone has only separated, has been with someone for 30 years, and just in the last 2 years, they leave because of probably domestic violence, or issues have escalated, or maybe there are infectious diseases, like we've seen. I've handled quite a number previously when I was in practice. I've handled cases where discordant couples separate because of reason of predisposition. So it should not be used against the surviving spouse, because their role in contributing to that estate is overwhelming. They've been there, they've nurtured children, they've contributed in decision making, they've also monetarily contributed. Like, you can all agree with me, women contribute so much beyond, you know, what we see on the physical eyes in running these homes and families. Actually, it is said lately that it's the women that are contributing financially, but they cover up, you know, for prestige and self-esteem and, you know,
and the ego.
social and the ego and the dynamics. So it would be really unfair for the law to come out and deny these women and only say the only exception is where there's approval for education, you know, you've gone for education, academic purposes, or you left because of your own will. Definitely you're leaving because of your own will, because of reason. So I believe this clause should be kept very well, but most importantly, be stayed until there's clarity and sanity. Because so many women have gone to the Middle East to work so that they can be able to look after their children. They leave their husbands here and the money and everything. God forbid if someone dies because of COVID. Would you be denied because you've been there for 3 years and yet you left when the house was built, you're paying education?
And actually even contributed to the roofing.
Exactly, the roofing. Actually, most of our friends, they go, they contribute, they build their homes, they start rentals, etc. So I'd also agree with the Fountain of Honor that this is a clause that should be either stayed until these others that are pro-affirmative action and gender equality are upheld very well. Yes, thank you.
Thank you for that explanation. I'll go to the domicile part. So of course, Section 15 was of the Act was so terrible. I would say it's one of the reasons actually the Act was ruled unconstitutional. So the new bill gives an option of women may take the domicile of their husbands, so it becomes optional. It also talks about whereby if they decided to divorce, that a woman has the option of retaining
The husband domiciliary?
no her own
Okay.
of choosing a domicile to belong to now that we are divorced. Can we talk about that whole issue and so what are the opportunities there in the bill, and so what are the pros and cons? Yeah.
Suzanne.
I think, for me, I think the question of domicile really should not affect one's right to inheritance. Yes, I think it's neither here nor there. Just because I may not choose your domicile, or we are even domiciled apart or whatever it is, should not take away the fact that as your spouse, by that very virtue, I benefit from that. And I was actually very excited by this particular bill where it makes the provision that it takes away, it corrects that little fault in the previous act, where they said that rights to the marital home were by occupancy. That is extremely unfair.
It's unfair.
Extremely unfair and extremely dangerous. Imagine this widow is not living in the country because she has to work abroad.
Exactly.
Do you know the advantages that an unscrupulous person could take of that? And they could successfully argue it out depending on which judicial officer they meet that day. I think it just put women in a very precarious situation. So the question of domicile really should not be one of the should not be one of the boxes that must be ticked. For one to benefit from their spouse's estate.
In other words, let their beneficial interest not be tagged to domicile, irrespective of where they are. Each case would be determined on its facts, so that we don't just have a blanket, a blanket generalized view that because you're domiciled here and there. So I believe it also needs to be revisited by our lawmakers, so that we don't allow any loopholes. Because unfortunately, when there are loopholes in the law, like the succession bill, they affect more the women. So we need to have some things clearly elaborated, so that the norms that we are trying to fight, or the historical gender biases and sensitivities, or even the gender stereotypes, don't manipulate them and say you left and therefore you're not going to be entitled to this. So I would really agree with you, Susan, on that.
So Isa, I'll go back to you and talk about, so this new bill seeks to create offenses, offenses, expiration dates, especially for the letters of administration. So in the past, people took advantage. So I'm an administrator, I decide to sell all the property, and there would be no one to come after me about anything, because it was not an offense. And maybe I would take the letters of administration, and because I have them, there is no other remedy for, let me say, the widow or the beneficiary. So this new bill seeks to create, expiry date for when after this the beneficiaries can apply to court and have those letters withdrawn, or an offense for whoever misapplies the estate and misuses it and uses it anyhow. What do you think about it? Are the restrictions enough? Are the offenses created? Would they go a long way into solving some of the issues around succession?
Well, the offenses being created, I think it's a plus for me, because if we look previously, people with the letters of administration took advantage of their position. And most especially where it related to, children, where children were involved, and the person with letters of administration was supposed to administer the estates. Then we have seen scenarios where uncles and aunties and grandparents disposing of land before, the children are of age and they can take on their, succeed their parents' property. And I've witnessed from friends and neighbors and colleagues who have gone through the same, and they did not have remedy. and you know this is person who is family, and they'll tell you if it was not for me you wouldn't have had education, and they make you feel they were doing you a favor because the property belonged to their brother or sister or whatever. So with the offenses created, well, they might not be effective, but at least it's a step towards the right direction. We're going to hold the people holding letters of administration accountable. You know, when you abuse this property, then if you know, I'll be held accountable for misusing this property, then at least that's a step towards the right direction. And also protecting the interests of the children and the dependents who will be, depending on that, the property. Yes, it is a good step. It might not be efficient. It might not be what we want, but baby steps. You can't fly without fast walking. So yes, it is a good one. We would, monitor and see if the offences are effective or they work. If not, there's room for amendment and proposing for more offences that are more strict to be included.
Marion, if I may step in,
yes, it's okay.
I would clearly say that like Izzy has said, the offences are very appropriate. They are timely. They're actually long overdue. Okay, they are befitting because we've had an era where there's a lot of intermeddling. A gentleman passes on today, tomorrow, they've already sold the car, the cattle, they're evicting the widow, as soon as they come back from the barrier. So, I mean, they are needed so that we can have respect, dignity, and honor of the estate upon the demise of any deceased. After all, the deceased work for their families to make sure that they can survive and have sustenance upon their demise. So these offenses are going to eradicate and curb the intermeddling, the losses and the damages that have been, suffered by so many estates and properties. And I believe, and I also pray that much as there is that aspect of the fear of the inefficiency, let the penalties be continuously reformed so that they are stronger and very stringent, so that people can approach succession and estate management with the dignity and the accountability and the seriousness it deserves. So that at the end of the day, if someone wants to be an administrator or if you're an executor, you know that you're not supposed to enrich yourself, but you're supposed to ensure that the beneficiaries benefit as per the laws. Then you also hinted on that aspect of the 2 years restriction. I mean, we need the restriction. You cannot administer forever in entirety, We really need the restriction to be there so that at the end of the 2 years, your grant and the probate has expired, and you need to account by way of inventory so that we know how you've administered. Otherwise, like you've said, we've seen executors flying around with wills in their pockets, sealed, and saying, I'm the executor of this will, driving the cars of the deceased, denying beneficiaries' interest. So we really need this reality. We embrace. It's a harsh reality, and it's unfortunate because so many of us have suffered that. So we really embrace the restriction of the law, the 2 years duration that has been given. It is needed, it is critical, it is very vital. Someone should know that within 2 years, this estate should have an inventory and the benefit should be the beneficiaries without any bias and inequality. So I thought I would add on that.
Yes, thank you.
Just to pick up from where Joyce has ended, in addition to having this, these robust laws, there is a need for all of us to be able to educate the public about these laws. There's a feeling that some of these laws are only for me and
women activists and feminists,
women activists,
lawyers,
feminists, the elite, and they have no benefit completely for
the women in the rural areas.
My relatives in Serre district. So they ignore it. So the only way people are going to be empowered also to demand this kind of accountability is if they know that an heir is not the owner.
Exactly.
If they know that the administrator is not the owner and that they're only their term is time bound. Otherwise, that very scenario that she mentioned will happen. What I don't know, Joyce, maybe you'll tell us, is whether at the grant of letters of probate or administration, there is any effort by a judicial officer to enlighten these appointees about their role.
They do it all the time.
They do
it actually. They explain to them. Even last week, I escorted my uncle who lost a wife in January. But they explain to them in detail that you're taking this for purposes of distribution of the estate as per the law.
And it's not
and then
yours.
You're supposed to file an inventory. It's not yours.
Yeah.
But like we've all said, once people have the probate, they think this is a certificate of ownership.
Of ownership.
Yeah.
So there's a lot that needs to be done to popularize, to
Absolutely.
educate, to get people to embrace this law, so that they also know that, one, I am here, it's a duty, you know, and I must not cross certain bounds. Otherwise, we fight a losing battle.
Actually, would have needed a man on this panel, I'm just thinking, because the men out there are going to think that it's about the women. Some people will just say we should not support the passing and the subsequent assent because of, but let me add on, this law is coming to enhance equality of widows, widowers, the children, no longer legitimate or illegitimate. So it's for all of us. Like Susan has clearly said, we need to do community awareness, sensitization. We can use the local language that people appreciate, so that someone in Masaka or someone in Budibujo or in Gulu, they can understand that actually the law is coming to help each one of us. It's not only for the elites. I mean, if someone sees a women here speaking a lot of English, they're like, I think this thing is about the women, but it's for all of us, and let us embrace it and make sure we can go on to train our women out there and the men, and also our sons, on the need to appreciate issues.
Well, I think the reason we're saying women, it's because it's women that we've seen affected with the previous the law that is in place. We have seen women being chased out of their homes, and it was highlighted in the case, the landmark case, that a widow once remarries, moves out of the of the property, of the matrimonial property. Then what happened to a widower who remarries? Are they also entitled to moving out?
Most women have
so
failed
you
to
find
get
that it's
married
most women
that
have been affected. And I think the reason we are saying it's protecting women, because finally we are seeing the light at the end of the tunnel. At least women's voices, their interests as widows are being highlighted in this new bill.
Actually, I was seeing that scenario of where most women, there's a friend of ours who are telling that, can you remarry? She's like, no, once I remarry, I'm going to leave this home, you know, and my children are used to this environment. But guess what? When the women die, the men actually remarry in that same home.
And they bring her
within just a couple of months, they've remarried, and the law was silent on that. So that this law is coming up to make sure that people don't hold on to their fears. Even when somebody remarries after 3 months, they're interested in the apartments they built with Mr. So-and-so is still that. But they can also remarry in that same home, as long as they're beneficial consent. Because when you look at the bill, it talks about disposition of the property, beneficial, assuming the widow says, I'm going to buy the property and give you the other percentage so that you share it, etc. So they can still remarry and enjoy occupancy without necessarily fearing, you know, that perception of the culture.
It should be okay, but as long as we do not get over our societal, our cultural, our moral fears. How do you bring another man
into my
gender
home,
bias,
to my son's home,
the ghost will strangle you.
But
yet the men are bringing women.
But how are you bringing another woman on in my daughter's, in my
curtains and my dining table?
I think, I'm sorry, the feminist in me is now, patriarchy has really made women fearful of whatever it is they need to do. You know, you can't bring because the ghost will strangle you. Then what happens? My ghost come and strangle you when you bring a woman in my previous house. And I think this law is really, one thing I love with the bill is that it is looking at all those, cultural irregularities and fears and the bad culture that people elevate to create fear among us women. And so women also need to understand that this law is for us. I'm going to say it's for us women who have been abused, who have been suffering because of culture and clan people and people who all think are entitled. To me, it's the Constitution says marriage is between a man and woman with the exclusion of others. Let it be so from the initial of the marriage. As I'm leaving my marriage and upon my husband being demised, I should be able to enjoy my sweat. Yes.
I think I'll give one last question, then we can have remarks, which is now on the tested side. There are those I don't know how to call heartless person dies, make sure he bequeaths his whole property to someone very outside the family, leaving the
I know.
leaving the 5 kids. We have seen these cases where children have gone to court and they're like, but my father has disinherited me because maybe I read of one case. He quarreled with my mother, or I married a Muganda woman. So the bill is talking about that. It's kind of making a provision for, I think, making it compulsory.
Yeah, absolutely.
For testator to bequeath. To bequeath the to the family, to the spouse. And what do you think about that? Do you think it solves the issues?
I think that was a very important part, addition to the law, because previously I think it was really a matter of the practice of testation that you must, but it was not mandatory by law that you had to. And I think it's very important for testators to make provision for their immediate beneficiaries.
Definitely.
You know, why we realize that indeed this is your will, and there should be no bar to how you bequeath your estate. I think there should be some leeway, like the previous, the practice was that you must give convincing reasons. I gave you that chibanja, you sold it. I gave you that plot, you sold it. I handed over my thriving border business. There were 10 borders. You ran it down. So your share is gone. You know, your share is gone. But I think I'm a little conflicted about that particular clause, because again, we live in a society where we have groomed entitled human beings.
That's true. That's true.
I have handled cases where people come to me and say, I want my father to show me my part.
Now. Before.
I know my father.
I'm told he got another woman.
He came to your office and he wrote a will. Show me. Because they assume that there's something in there for them. You know? So in as much as that clause is meant to ensure that the family is not left despondent, I think we also need to be very careful how we explain it to people, how we approach its application. Otherwise, this entitlement
will bring laziness among our children to work, and
it's only just going to escalate.
Since sons want to kill their fathers.
Oh, not once. There are cases of
so.
People killing their parents.
Especially
like the recent issue I heard about a son who killed a mother because the mother had refused to give her the share of the property.
It's sad.
So it is sad, but this is the society we're living in. So we need to really be careful on explanations so that people know it's not about entitlement, but that's what the law thinks. And also, if I might say about protection of the matrimonial property to the surviving spouse, to me this is really key because we've seen cultural heirs coming and saying, this was my brother's house. I'm the heir. You're not from our clan. Please vacate. So even where there is a will and it has disposed of all the property, the fact that this law is coming to protect that matrimonial property that the surviving spouse is living in, to me that is a huge landmark. At least it will protect most women who have been evicted from their own properties because they lost their husbands.
I would agree with that entirely, and I think it's going to help us so much. But like Susan has mentioned, we need to approach the other clause to do with the compulsoriness and the mandatoriness very carefully and very delicately. I know it's very vital for people to have a beneficial interest, but like she has ably mentioned, we don't want to nurture a generation that solely looks up to beneficial interests instead of working for their own legacies. So we need to know how we are going to explain it. And that takes us back to sensitization, empowering, training people, creating awareness sessions, going to the village and telling people, much as your father has all this estate, but at the end of the day, you need to work so hard and make your own legacy. Yes, Marion.
Yes. I think I would, on that, I think also it's important to highlight the fact that now women can dispose their own property without the consent of the husband.
That's true.
One of the things that but then the thing of disposing also what she's entitled
Exactly.
to in the will.
Yes.
Which is okay.
Yeah, it
Yeah, 'cause
should be
people
because
could-
it's
be
hers.
okay.
Yeah, because we've been suffering situations where a man leaves a car,
Yes.
you want to sell the car, probably buy another one
Yes,
as remembrance,
and you cannot
and
do
then
it.
people say you probably killed the person, that's why you're quick to sell.
I'm telling you, even after judgment, everyone says,
Yes.
"Oh, this one,
Yeah, this
must
one.
have bewitched the
Yeah,
husband to
must
die."
have bewitched him. Maybe she spiked the what with poison, you know. Yeah,
The
so it's really a very good
speculations,
clause. I
yes.
really like
Yeah.
it, the disposal clause. Yeah.
So let's give our last remarks. What would you like to tell the audience? What should they do? Where should they go in case these things happen to them? You know, widow is in trouble. Maybe children have been kicked out of their homes. Like, give us our takeaway for today. Israel, and what first?
Israel is the first one. Okay, thank you for getting the first opportunity. Well, to me, my general comments is this bill has come to remedy the so many lacunas that we've had in the previous law. And in as much as it might not be perfect, we think we need to appreciate the steps that we've taken. And like my colleagues on the panel have been suggesting, that we need to really sensitize people on what this law is all about, because it will not make sense for the law to be passed and you know, people do not understand the nitty-gritties of it and what it means. And also, working from FIDA Uganda as a feminist organization that are there to, you know, give legal aid services to women that are vulnerable. In case of any challenges, you know, with intestacy, with inheritance issues, we handle all those cases. So they can as well walk into our offices, and we are located in over 20 districts in Uganda. So yes, you can reach out to us or any other legal service aid provider near you, and you'll be able to be assisted. I'll talk on behalf of women. We would help women because the feminists in me cannot do the other side. Yes, and thank you very much for the opportunity. It has been really interesting to have this conversation with my colleagues.
Joyce, yes.
Yeah, one thing I have to say is that this bill is a beacon of hope for the women fraternity because it's trying to enhance our inheritance rights and our beneficial rights in case of intestacy. So we need to pray that it is passed. Then also, for me, it's a very strong tool for empowerment. I embrace it. I want to also shun any form of cohabitation. And I want to encourage the people out there who are still in cohabitation relationships. Please work so hard to make sure that you normalize everything. And I believe that the future is bigger for the children out there, and most importantly, the different stakeholders in succession. Thank you so much for hosting us today. I'm humbled to be here and to have a beautiful conversation with everyone.
This bill has excited me a lot. It excited me for a number of reasons. One, it you know, increases protections to women.
Yeah.
You know, raises the status, the dignity of women, which is something which the women's movement in Uganda has been striving for years.
Yeah.
So it is something to be celebrated, and I sincerely hope that the head of state will pass it.
Yeah.
The other thing that excited me about it was the enactment process. There was not so much controversy around this bill.
Yeah.
To the extent, I mean, that the government was able, because initially it was a private member's bill, but government, when it brought its bill, they were not so different. You know, they were not so different. So I also hope that this particular bill is a benchmark for the next debates around legislation that relates to women's rights. I hope we can draw lessons from the way this bill was handled. Now, for the women in particular, what I always urge women to do is to take an interest in matters of policy,
Exactly.
matters of the law. It is something we do not pay attention to, and yet these are things which directly affect us.
That's true.
But if you do not know your rights, then there is no way you're going to be able to protect yourself or to even start asking for redress, because you do not know, you know. And the other thing I always, now that there are rights that have been accorded to women in this bill, for example, the right to dispose of property, the right to continue owning even when you remarry, I think, again, for me, the question of contribution is such a big deal. I think women should stop being shy about keeping track of their contribution.
Absolutely.
In whatever
Absolutely.
form, whether it's material or financial. If you have
Emotional.
your kadala of tomatoes and you know you've been throwing money in a box, and at the end of the month, you and your husband go and buy 10 iron sheets. Please ask that that receipt is written in both your names and have a copy of it. Yes, it needs to become normalized because how then do you prove your contribution? Yeah. Thank you.
Thank you so much. It was lovely having all of you on this panel. That is it for today. Once again, we are the Women's Show on Civic Space TV. You can get us on our social media handles, Twitter, Instagram, YouTube. Catch up with us next week, same time, same date. Thank you. Bye.